In the meantime, to discuss the court ruling on Section 84, subsection 8 of the Electoral Act and its legal implications on the 2023 general elections, when I'm being joined by ARISE analyst and lawyer, Barrister Frank Tietie, as well as ARISE Judicial Editor, Tobi Soniyi. Thank you so much, gentlemen, for joining us tonight on the program. That's Soniyi, that is. Gentlemen, let's have this conversation, by the way. We'll talk about David Mahi and that breaking news. But Frank Tietie, I want to start with you. The fact that that court in Kano State has ruled, and the APC, according to its publicity secretary, says we're not going to adhere to that ruling because subsection 8 of Section 84 is still in limbo. Let's talk about that and the way forward, especially looking ahead of the primaries of the APC.
Well, thank you very much. It's a kind of difficult situation for the party. It cannot pretend that it does no longer know the position of the law. The idea of a declaratory judgment is simply to state what the law thinks or what the law is about a particular situation. And what in this case is saying that statutory delegates are not excluded. The ruling or the judgment is in a very negative sense, in the sense that it is not stating directly that statutory delegates are to participate in the coming primary. More especially, which is very importantly, is that the order did not make any consequential order. I mean, the judgment did not make any consequential order to the extent that such and such a thing must be done. It simply states that this is the position of the law. So the APC, knowing the position of the law and still going ahead against it, it's going to be a difficult situation for it. However, to now also consider that a lot has been put into organizing the primary, considering also the national judicial policy to judges across the country. The expectation is not that it should affect the current primary that the APC is just about to begin.
All right, thank you so very much. Let's cross to Offsite Studios, where ARISE Judicial Editor Tobi Soniyi is there. What kind of judicial lacuna this may cause, despite the summary that Frank had given, that is just declarative and it has no weight of law whatsoever? Can the court, make pronouncements when an act or a bill has not been signed into law?
Well, thank you, Chris. First and foremost, I think we need to understand that the plaintiff, I think they made a fundamental error by refusing to join the party, the All Progressive Congress, to the suit, because in law, the party is not banned by another if you are not made a member. And I believe I want to agree with the publicity secretary of APC that since the party was not joined, they are not going to, because you cannot enforce a judgment against someone who is not a party on record. So the plaintiff will not lose anything by making APC a party. So having failed to do so, the APC can argue that, well, there is no order against us. I consider that they joined the chairman of the party, but like Mok has said, the chairman of the party is not the party. So to that extent, I think the APC might be on a good legal stance to ignore the judgment. Then secondly, the Chief Justice of Nigeria has issued a practice direction on electoral matter and political cases and had cautioned judges to be very careful. Now that the game has started, the judge should probably have been cautious, and he would not lose anything by allowing all the party to argue their cases before him, before arriving at a judgment, so that he doesn't seem to be extending the goalposts when the game is already on. For instance, the PDP has done its own presidential primary, and by this ruling now, the two different parties will be adopting two different procedures.
Well, Well, Tobi, it's not just the
Chris.
PDP, by the way. Of course, we've seen Labour Party and even ABGA. They have now their presidential flag bearers. Frank Tietie, I see you shaking your head. It's like you disagree with what he's saying. But a lot of people are looking at the timing, because this is coming after some parties, just like Tobi had said, have done their primaries.
You know, we need to understand something very clearly. The judge has done no wrong. He has been given an opportunity to make a pronouncement of what the law thinks about Section 84, subsection 8. And it states that it does not exclude statutory delegates. The judge didn't say include statutory delegates. The judge didn't order APC to include statutory delegates. But anybody, any Nigerian who has the opportunity, who had the opportunity to have approached the court as they have done, the plaintiffs have done, they have approached the court to say, tell us whether or not Section 84, subsection 8 excludes statutory delegates. And the court says, no, it doesn't exclude them. And simple. And then the court has simply stated the law. And there is nothing to be enforced with regards to that declaratory judgment. It's a declaratory order. These are stated the position of the law. It is left for the APC to advise itself whether or not that there could be some, pitfalls, some landmines in the future. But the good thing about it is that there is a question that is yet to be answered. The plaintiffs who went to court, are they supposed to be statutory delegates? Are they entitled to vote in the coming primary? If they don't, they have done the only good they have done is to educate the public that the position of Section 84, subsection 8 is that statutory delegates are not excluded. There's a very important thing that we must take home from this judgment. It means that while the National Assembly has been struggling to amend Section 84, subsection 8, seeking the consent, the assent of the president, it only takes one judge sitting somewhere in any federal high court across the country to simply decide, interpret the law in a way that suits him, and then things will just change. So the courts are sitting in a very dangerous position in our electoral practice. It means that they can overturn things overnight, and that's dangerous. That's why we must pay attention, just like my colleague has said there, pay attention closely to what the National Judicial Council policy direction is. Don't make orders that will truncate already arranged elections. A lot go into elections in terms of logistics and human and personnel management, and then one judge sitting in Kafashan or in Warri or somewhere simply makes an order and then to turn things upside down. The good thing is that there is nothing to be enforced with regards to this declaratory judgment. The APC will advise itself, and the parties who are in court may not have any interest. And again, if the APC goes into that primary election with the understanding that the state of the law, nobody quarrels about those who should be delegates or not, and then it is safe to actually ignore the judgment. But that is the law as we speak in Nigeria now.
Shouldn't that law be challenged? Let me put this before Tobi. Tobi, don't you think the law should be challenged as it is now, so that it does not generate any brouhaha, political brouhaha in future?
Yeah, thank you, Chris. I've not seen the process, but I'm aware that the national chairman of the party has said that he's going to challenge that judgment on appeal. And the other parties there are National Assembly, the speakers, the Senate. We don't know, too, whether those ones will challenge it. But certainly, it is a judgment that should be challenged on appeal, because even the substance, I must concede that we are bound by a court order. The judge could be wrong or right, but that is the law, so we agree. But nevertheless, the section he relies on, Section 223 of the Constitution, does not have anything to say. It doesn't deal with delegate at all. It talks about the party ESCO of a political party, the executive of the political party. So how a judge will rely on a section that does not deal with delegates to now say delegates are, statutory delegates are not excluded is baffling. But like I said earlier, a judge may be wrong or right. It does not lie in my mouth. It's only an appellate court that will change that. So there are very good ground for appellate court to set aside that judgment.
Yes, very good grounds indeed. Nigerians don't want anything that is going to truncate this democracy or cause some due lacuna there. Thanks so very much, Tobi Soniyi, ARISE Judicial Editor and Deputy Director News, and Frank Tietie, ARISE Analyst and Rights Lawyer. Thanks, gentlemen, for coming on News Now.